Good afternoon, good evening, and good morning, wherever you may be listening and viewing this webinar. My name is Tom Dustman. I am a member of the Missouri District Export Council, and I also am the Midwest representative on the board of directors for the National Association of District Export Councils. And it's my pleasure to welcome all of you to the webinar today. We have a very timely topic for all of us to learn and to be prepared to implement where necessary. And before I turn the microphone over to David Cole, I wanted to let everyone know that this webinar is being recorded, and we will share the recording and the webinar with all those who wish to see it through the NADEC website. You should also know that we have the chat function that we are monitoring, and we would like for you to hold all of your questions towards the last part of the presentation. We have around 15 to 20 minutes or so for questions and answers before David will make his closing remarks. So again, thank you very much for your attendance. And David, I'll turn it over to you.
All right, thank you very much, Tom. Welcome everyone to our program presented by the District Export Council of Oregon with support of National Association of District Export Councils and support from the U.S. Commercial Service. Our program today is entitled Export Sanctions, a review in light of current world affairs. We're very fortunate we have two experts in the field, John Yormick, who is representing the Northern Ohio District Export Council. Fortunate to have him here today, and Flannery Georgalis, LLC. Mr. Yormick's business law practice concentrates on international business transactions, trade, and dispute resolution. Represents and advises clients on export controls involving the Export Administration Regulations, EAR, International Traffic in Arms Regulations, ITAR, Office of Foreign Asset Control, OFAC, Sanctions, Anti-Boycott Regulations, Deemed Exports, and the Foreign Corrupt Practices Act. So very interesting to have his insight into our topic today. And then also we have very fortunate to have Mr. Akana, who's with the Oregon District Export Council and the Buchalter law firm. Mr. Ma works with clients conducting business in global marketplace to structure effective and efficient transactions to comply with U.S. and foreign laws and regulations, transfer and protect data and technology, intellectual property and software, negotiate contracts for the sale and distribution of products and services, and to establish foreign offices and manufacturing facilities. So again, very relevant to our discussion today. So as was mentioned earlier, we are looking forward to having a dynamic discussion. We will have the two presentations and then have plenty of time for questions and answers. You can put your questions in advance into the chat, or you can use the Q&A function as well, which tends to work pretty well. So I would recommend the Q&A function, but either way is fine. You can also raise your hand if there's something urgent, but we do want to keep the program on track. So appreciate that. I'd like to turn it over to Kelly Holloway here to say a few words on behalf of the District Export Council of Oregon. Kelly?
Hello and welcome to everybody, and thank you to all the District Export Councils from Northern Ohio to the NADEC to Oregon. Appreciate your support and collaboration. I'm Kelly Holloway. I'm the director of the U.S. Commercial Service, and we rely regularly on the Export Council and all volunteer board of private sector international trade experts for a depth of expertise in their respective area as we work with companies in the community. Through Oregon, covering Oregon and Southwest Washington, our office supported some 800 businesses last year with different types of inquiries. And as you can appreciate, every situation, every need is different. And so I couldn't do it. Our team couldn't do it without the support of the DEC. And we exist to help companies export more. So I welcome the chance to support any Oregon businesses, to refer you to my colleagues in other markets, and help make those international transactions a success. I'm going to do my best to post useful links and information as our experts go through. There may be acronyms and other, terminology, or they may refer to sites for training. So I will try to work that in. And at the end, David will mention our the Lunch and Learn series of the Oregon DEC, of which he's a board member, and looking forward to the content today. Thank you.
Well, thanks, Kelly. Yes, I was remiss in mentioning that I am a member of the Oregon DEC. I'm also the lead and liaison for the Oregon Small Business Development Center's Global Trade Center here in Oregon. So with that, we'll get going here. Kelly did put the bios for our speakers in the chat, so you can see their extensive background and experience. John will start off with an overview of sanctions in general, what they are, and then Akana will follow up with some specifics related to Russia and Belarus in particular. So with that, John, please.
Thanks very much, David. Kelly, Richard, a special thank you to you for involving me from here in Cleveland, where it's a little bit beyond lunch and learn. It's nearly dinner and learn, of course, but I'm happy to join and very pleased to participate in today's program. As David mentioned, I'm going to give a brief background with respect to sanctions in general, as well as touch on export controls. Based on the roster that was distributed, there's certainly plenty of expertise. And for those of you who are more advanced than others, think of it as a refresher, or check your emails or what have you, while I try and lay some of the basic foundation for those who might be newer to export controls and sanctions. So I'm a guest. I don't want to overstay my welcome. I'm going to move fairly quickly. Let me set my timer here to try to keep myself on time so that we can get to a lot more substantive content from Akana. So sanctions really are how a lot of foreign policy is set these days, and we see it in motion currently. A lot of that comes through executive orders issued by the president. And then later, when time permits, the regulators at the Office of Foreign Assets Control, part of the Treasury Department, have a chance to catch their breath and write the actual regulations, which are found in Chapter 31 of the Code of Federal Regulations, Section 500. So OFAC is a fairly small government agency, but it carries a big stick. And what they really specialize in is following the money. And certainly we have all heard of yachts and planes being seized in recent weeks from Russian oligarchs who have found their way onto the bad guy list, known as the specially designated national list. So they're very good at tracking the money. And that means they're able to wield a lot more power than what their small size would otherwise indicate. So as I mentioned, usually sanctions come out as executive orders signed off by the president in response to some world activities. It could be anything from a cyber attack to human rights violations to a change in regime that has now led to a different foreign policy stance that the U.S. has, as well as protect our national security interests. In the interim, between the executive order being issued and the regulations being issued or published, we see a lot of guidance, or perhaps we don't see enough guidance or enough clear guidance, many would argue, from OFAC. And they tend to issue guidance these days through FAQs, such as those that were issued just this morning with respect to some of the newer Russia sanctions and the prohibition on certain services, accounting services, corporate and trust formation services, and essentially what amounts to business consulting services or even brand management. So the guidance is really what businesses need to rely on, especially those that are hesitant at first and decide to shut everything down. Very often when I'm talking about sanctions at a presentation, I like to title it Compliance Challenges and Opportunities. It's not for the faint of heart at times, but with some time devoted to reviewing the sanctions carefully, you can often thread the needle, and without a specific license from OFAC can proceed with that transaction, with that sale. Now you have to document that process, that analysis, that review very carefully. And with apologies to Tom, I like to say that everyone from the government is from Missouri. Show me. If it's not documented, it didn't happen. And when you're talking to a regulator from the Office of Export Enforcement, or if you have the worst fortune of talking with someone from the U.S. Attorney's Office or Department of Justice, National Security Division, FBI agents, you certainly want to have that documentation to show them what due diligence, what homework, if you will, was performed, as opposed to, well, we were selling X works, we put it at the dock, they took it away, where it went, we're done. Doesn't work that way, not in the least bit, as I'm sure most, if not all of you know. Sanctions come in various flavors, let's say. Not all sanctions programs are created equal. Some are comprehensive, such as those programs in place for Cuba, Iran, North Korea, Syria, Crimea, essentially. Others tend to be targeted programs where specific parties, whether individuals or entities, are targeted for sanctions. Not all sanctioned parties are subject to asset freezes and complete prohibitions in terms of how you can transact business or how you cannot transact business. So the devil is in the details, and that's really one of the reasons why you need to step back and spend the necessary time to review and analyze, look for opportunities, should they exist, before walking away from a potential transaction. I mentioned specific license earlier. There's also general licenses. It's essentially a blanket authority that OFAC issues with respect to certain parties, certain types of transactions that are going to be authorized. Now, again, the devil is in the details. You have to pay close attention to what the conditions are, what the scope of that general license is. Many of them have very short fuses to them. For example, once sanctions are issued and a general license might be rolled out in order to complete a transaction, in order to complete shipments, divest of certain assets, wind down the affairs of a joint venture, etc. Others are more open-ended, longer term, but they're not necessarily perpetual. So again, most will have an expiry to them. So you have to pay close attention, and there are instances where there are certain reporting requirements as well. But that is your authorization to proceed with the specific transaction that is set forth in those general licenses. So that's always a first place to look in terms of whether you can transact business or not in the face of sanctions. Now, we saw some early questions through the registrations, and a couple folks asked about China. I'll simply say this about China right now. China is really not subject to significant sanctions. There is a sanctions program. It's really focused on military companies, and it really prohibits investment in companies that have been designated by OFAC as military government-controlled companies. However, we'll segue with China into export controls. And we have seen a significant increase in export controls through the introduction of the military end-use and user rule and the MEU, or military end user list, that has dozens and dozens of Chinese companies on that list. We see it on the entity list. These are both lists that are maintained and administered and enforced by the Commerce Department, Bureau of Industry and Security. Those companies that appear on these lists trigger a license requirement for the export from the US, for the re-export from a third country, or for the in-country transfer of items that are subject to the export administration regulations. And sometimes it's very general, sometimes it's more specific in terms of what the items, software, and technologies are that require an export license. Then you have certain license review policies ranging from case-by-case basis to a policy of denial. And in between, there is a presumption of denial. So again, the devil is in the details, like the sanctions. So I'm not going to continue on other than to say that David mentioned that this is a timely topic. It certainly is, particularly when we have the Deputy Attorney General, Lisa Monaco, saying about 6 weeks ago at a New York City Bar Association meeting that sanctions are like the new FCPA, Foreign Corrupt Practices Act. So you get it from the number 2 at the Department of Justice that sanctions and the enforcement of sanctions and the potential prosecution, not simply civil enforcement, but also criminal prosecution of sanctions, violators may be forthcoming. So with that, I will be turning it over to Akana to walk us through some more of the specifics of the Russia.
Okay, well, thank you, John. Before we switch over to Akana, there was a question in the chat about sources for information on sanctions. Your firm posts updates on sanctions from time to time. If you wanted to put your website address for your firm's updates that in the chat, that would be great. And are there other sources or websites that can provide some of these updates? John, you're muted.
There are, all of the government agencies have a subscription service. So I mentioned that this morning. OFAC issued some guidance. New guidance came out on the services, the accounting services, corporate formation services, et cetera. So you can subscribe to the various notifications, whether it's OFAC or BIS. Certainly, there are any number of trade publications out there that report on these issues almost in real time, really. There's Akana, I'm going to guess that your firm puts out client alerts or other types of insight documents. There's a lot out there, almost too much. We have information overload at times. But I try to rely on the government sources, go straight to the horse's mouth, so to speak.
Okay, well, very good. Thank you for that. Akana, please.
Oh, thank you, David. Thank you, John, for your eloquent introduction to sanctions and discussion about export controls as well. I would like to thank the National DEC. Tom, thank you for your support. I'd like to thank the U.S. Department of Commerce, Kelly Holloway in Portland, and members of the Oregon DEC. Thank you, David, for being our moderator today. And also, I would like to thank John for being my co-speaker for today. It's a privilege to be here with you all. And I'm going to move the discussion to a more specific discussion of the Russia-Belarus sanctions that have been so much the topic for a number of months up to the present. But as we'll see, those sanctions have their origins in a much earlier time period. I'm going to share my screen because I have a presentation that, by the way, I will tell people the presentation is a presentation that could take hours or a day to go through. I am not going to belabor that and threaten you with that amount of time. I'm going to try to pick through that and augment the discussion that John has already just started. But the full presentation will be made available by Kelly Holloway and the Oregon DEC for anyone who's interested. So hold on, I'm going to try to share that screen and we'll continue. So as others have mentioned, I'm going to take the discussion more in the direction of the Russia-Belarus sanctions specifically. This first slide mentions the Crimea annexation in 2014, and really the current sanctions that are so much in the news regarding Russia and Belarus really have their origins in the first invasion of Ukraine by Russia in 2014 and its subsequent annexation of Crimea soon thereafter. Certainly the sanctions, though, have become the broadest sanctions, the largest in scope, and the most biting of any sanctions in the post-World War II period. As we'll see, they're not just financial, they're not just energy or sectoral, in that they're not just addressing a particular industry, but many industries, including many individuals from the Russian government, high-profile oligarchs, and as we'll also see, even the family and friends of Vladimir Putin. The sanctions really have also their origins in the fact that the US government in 2018 to present have been unexpectedly pleased with the effectiveness of sanctions that have been imposed against Chinese companies, namely Huawei and ZTE Communications in recent years. And the Russia and Belarus sanctions really are an expansion of the playbook by the United States government. Now, the response to sanctions by the US, the UK, EU, and certain Asian countries has not been uniform around the world. countries in the Middle East, many in South America, certain ones in Asia, as well as almost consistently through Africa. These countries have been either reluctant to sign on to sanctions by the Europeans and the North Americans, or they have actually been opposed to them on the grounds that engagement with Russia and not opposition to Russia is a more fruitful pursuit. I think only time will tell which line of thought will bear more success, and we'll have to wait and see. This slide shows some of the milestones that have prompted sanctions, including the Crimean invasion, the declaration of independence by the Donetsk and Luhansk People's Republics, and certainly John mentioned the commercial products sanctions that have been promulgated by the Department of Commerce, as well as the Office of Foreign Assets Control. These next two slides are a rough litany of sanctions that I put together from just before the invasion in earlier this year to the present time. You will see that there have been a slew of regulations put out almost on a weekly basis, and this list is by no means comprehensive. I've simply chosen a number of prominent dates when a number of particular sanctions have been initiated either by executive order of the president or as implemented by any number of federal agencies. Prime among them would be, as John also discussed, the Office of Foreign Assets Control with the Department of the Treasury, responsible for economic and policy-based sanctions. Sanctions rolled out by the Department of State, DDTC, which is the agency responsible for export controls and sanctions in the broader sense with regard to military products and services, and then the Bureau of Industry and Security of the Department of Commerce, which is responsible for commercial sanctions, commercial export control restrictions, if you will. And those were the restrictions that John mentioned when he was talking about restrictions on products that are based upon their listing in the Commerce Control List for the Export Administration regulations. There's this. I mentioned on this slide that the sanctions have actually, in the estimation of some people, gone somewhat over the top in that they are addressing restrictions on particular individuals close to the president of Russia, Katerina Tikhonova, Maria Vorontsova, Maria Larova, and also Alina Kabeva. If any of you know who they are, you get extra points, but since that will take too long to do a poll, let me just say that the two individuals at the top are the daughters of Vladimir Putin. The third person is the wife of the foreign minister of Russia, and the last person, Ms. Kabeva, is let's say she's a close personal friend of Vladimir Putin. So the sanctions have really gotten quite personal. They involve many industries, quite prominently the Russian oil and gas industry, the banking industry, and the aerospace industry. And later on in the slides, there are a number of slides that deal specifically with the aerospace and aviation industry in Russia and sanctions against those. I do mention in the list here Roman Abramovich, who is a prominent Russian oligarch. I mention him because not only has there been a number of sanctions to identify, seize, detain, and convert assets by Mr. Abramovich on the basis that he is holding them for the benefit of Russia and also for Vladimir Putin. But also I noticed, I mentioned him because he is one of the few Russians that have actually taken the efforts by the United States government to confiscate personal property of Russian oligarchs to court. And so we'll see at the end of this presentation that there's been a recent court decision upholding the US government's right to seize his personal property. So, as John mentioned, the sanctions are not all comprehensive, are they, as they are in North Korea or Iran. But what can a business do? So my suggestion is if a business is interested in maintaining business with a Russian party, and as we said before, although sanctions are severe, they're not all encompassing, and it's not an embargo as of yet. So businesses should early vet who they're doing business with. In other words, they should determine whether they're dealing with a restricted party under US law. They should also determine, are there other sectoral sanctions from OFAC or other agencies, such as bans on doing banking transactions with certain Russian entities or doing business with the Russian energy industry. So in other words, know your partner, know your customer, know who you're doing business with. John touched upon the export controls that are promulgated by the Bureau of Industry and Security on commercial products. Also a reminder that under the ITAR, there's almost a fairly solid requirement that an export license be obtained for any military products or services. However, there's a presumption of denial for any such licenses. So in effect, it's difficult to do business with a Russian recipient of a U.S. product that is either listed in the commercial regulations or listed in the military regulations. Lastly, I think companies should also make sure that if they're doing business, that they also are aware that there are sanctions on regions close to Russia, such as Crimea, Donetsk, and Luhansk, and also to be wary of new orders from companies that may be in countries, although not Russia or Belarus, those countries that might be sympathetic or friendly to Russia as a location for a possible diversion of U.S. products to Russia and Belarus. As we both talked about, payments to vendors and payments from customers are becoming increasingly difficult because of banking sanctions, because of restrictions on investment in Russia. There have been threats also by the Russian government to confiscate and to nationalize intellectual property assets that might be developed by U.S. or foreign business entities that are doing business in Russia. As an example, there are so many U.S. software development companies throughout the United States that have development teams in Russia and Belarus, and there is the risk of those assets being nationalized by both countries. And also in the context of mergers and acquisitions, companies need to be aware that even if a transaction is completely domestic, a target company of a merger or acquisition, if they have a subsidiary or an affiliate company in Russia or Belarus, there will be government approval requirements and other due diligence and perhaps remedial actions necessary to conclude that merger and acquisition transaction, simply because part of the target company may be in one of the restricted countries. Now, the next couple slides, I'm not going to go over in any detail because they really supplement they support what John mentioned about the commercial regulations. this slide mentions the citations to the Export Administration Regulation restrictions on commercial products and the Commerce Control List. This slide mentions that there are restrictions on the foreign direct products of restricted technology and products under the EAR as well, something that John also touched upon. But here are some of the citations for you. I'm not going to talk about this topic too much, but suffice it to say, because of the lack of time, but suffice it to say that Russia has threatened a number of countermeasures to make doing business in Russia even more difficult. Principal among them, the acquisition and sort of nationalization of intellectual property assets that I mentioned earlier, and also a requirement that Russian companies convert any foreign reserves that they may earn from business with non-Russian entities, that they are required to convert that into rubles. And that makes it even more difficult for US subsidiaries to do business there. Now, who's enforcing these sanctions? There are enforcement divisions of all of the major federal agencies involved with export controls and sanctions, those being the Department of State, Department of the Treasury, the Department of Commerce, and the Justice Department. There is one federal task force that has become quite active recently. In March of this year, the president announced the creation of Task Force Klepto Capture, a catchy name for a task force comprised of all of the four agencies that I just mentioned. They have the responsibility of identifying and seizing and converting property owned by Russia or owned by individuals for the benefit of Russia or sanctioned Russian individuals. And again, the reason for mentioning Mr. Abramovich, who is an owner of a number of steel industries in the United States, and principally Evraz Steelworks, which has offices throughout the United States, but particularly in the Pacific Northwest. Like the other agencies, the Department of Treasury, Financial Crimes Enforcement Network, or FinCEN, has also been active in enforcing the Russia-Belarus sanctions in the financial industry, and it has recently issued guidelines for banks and other financial institutions to ensure that they are aware of the sanctions and that they follow best practices in order to avoid being sanctioned themselves. The next number of slides have to do specifically with the aerospace and aviation industry. I've chosen that because that's an industry that has been prominently in the news. Suffice it to say that Boeing, Airbus, any number of US OEMs in the aerospace industry have left the Russian market, the Belarus market, and that the US, UK, and EU have been very active in the process of seizing Russian aviation assets to the tune of about $62 million in value of Russian assets that have been identified outside of Russia. However, I'll also mention, though, that despite Europeans and the North Americans closing airspace, freezing and seizing Russian aircraft, that sort of pales in comparison to this slide and the statistics shown here that authorities have estimated that US and European aircraft leasing companies have about 600 foreign-owned planes that are being held captive by Russia, and Russian companies are refusing to return those aircraft to US and foreign leasing companies to the tune of about $12 billion of possible losses for the aircraft leasing industry. So That's one example of an industry really being hurt by as sort of collateral damage as a consequence of the Russia-Belarus sanctions, which frankly most people see as absolutely a necessity, despite that hurt to a particular industry because of the gravity of the invasion of Ukraine. Now, there have been a number of lawsuits and legal proceedings that have been initiated as a result of the Russian and Belarus sanctions. This slide shows two lawsuits, one by AerCap Holdings, an aircraft leasing company, which has sued a Russian airlines for $427 million because they have refused to, you've guessed it, they've refused to return 8 Boeing aircraft to AerCap Holdings. In turn, an Italian financial institution has recently sued a subsidiary of AerCap and another company for because of their inability to make payments to their bank. And so this slide is basically an example of the ripple effect through the aerospace and aviation industry because of the Russian sanctions. So the hurt because of the sanctions in many cases goes both ways, both hurting and restricting Russian entities, but also there are effects on the other side as well. One question is, are these seizures of personal property lawful? It's a question that many in the legal field are asking, and we have an interim decision by the U.S. District Court for the Southern District of New York, which came down just 3 days ago, and the answer, at least for now, is yes. The U.S. government has the authority and has been supported by this federal court to identify, attach, and convert 2 planes owned by Mr. Abramovich, a Boeing 787 and a very nice Gulfstream personal jet, as you see in the slides. So we suspect that there'll be plenty of legal proceedings to test the effectiveness of sanctions going forward. But for now, this seems to be the latest word on the effectiveness and authorization supporting the sanctions. I'm going to close by just mentioning that companies do certainly need to pursue an enhanced due diligence process if they're planning to do business in or continue to do business in Russia and Belarus. This slide shows some of the things that should be done, including a better effort at knowing your partners, as well as other matters which both John and I have mentioned. The last thing I would mention is that although sanctions have been a restriction on Russian entities, the Russian government, and in certain cases also non-Russian entities such as the aviation industry in the U.S. and Europe, many see the war in Ukraine as also an opportunity to provide goods and services to many of the NATO countries that are supporting Ukraine, as well as to provide goods and services, in many cases of a military nature, directly to Ukraine. I've been involved in a number of transactions of this kind recently, and what I would mention as tips for doing getting into that kind of business is there is no shortcut for avoiding a thorough and comprehensive export controls application, either to BIS for commercial products or for DDTC for military ones. And we've seen in recent months that a lot of companies, in their haste to ship goods and services over to Ukraine, that they sometimes give short shrift to their filling out of applications, more so than they might have done before the war started. DDTC and BIS have both told me in recent discussions that companies really shouldn't shortcut that process. And then lastly, I'd also mention if you're exporting to Ukraine, make sure that, and even if the exports are going to Poland, assembled or
Well, it looks like we have a little bit of a bandwidth issue here.
sorry.
Go ahead. I lost you there for a minute. Okay, well, sounds like Akana was finishing up there.
Anyway, thank you all for your attention, and I'll turn the program over back to Tom and to David and for questions.
Well, thank you, Akana. That's very interesting information, very useful. Thank you, John, as well. This is obviously a very important topic that we all need to be paying attention to, and the fact that it is so dynamic, we need to be paying attention on a daily basis as to how things are developing. So this is very interesting information. I would like to encourage people to put questions into the Q&A function. We're about to enter our Q&A time here that we have left, and also in the chat as well. Let's see, we do have a question for Akana about U.S. sanctions. Do those apply to foreign-owned companies that are operating within the U.S. or exporting from the U.S.? It looks like Akana's still frozen up there a little bit. John, do you have a comment on that?
Yes, they are still going to meet the definition of a U.S. person if they are a subsidiary of a foreign company, but are incorporated or organized in any of the U.S. states or territories.
Okay, well, very good. Okay, so we can make sure that everyone has the information that they need, that we're dealing with, and try to eliminate or reduce any problems with the regulators. So any other questions out there? This is a great opportunity for people to bring up questions or concerns that they have with their specific business operations, specific industry. And I welcome any comments or questions.
David, I'm going to answer one of the questions that came in through the registration, asking about potential penalties for working with Russia-based service providers. The penalties, there's a maximum penalty would be in excess of $300,000. However, there's plenty of factors that come into play in terms of that dollar amount, but certainly you want to keep that in mind and do your due diligence, as Akana was explained in the closing slides there. Again, because the sanctions are not comprehensive, at least not at this point in time, outside of Crimea, Donetsk and Luhansk regions, there may be an opportunity to conduct business, and in fact, Akana and I both have clients doing just that with Russian counterparties, whether they're suppliers or customers, distributors, what have you. So it's going to be fact specific, but Akana, do you have anything to add on that particular question?
John, my internet connection was unstable. So
oh, sure. I'll repeat it. I read one of the questions that came in through the registrations, which was, what are the potential penalties for working with Russia-based service providers?
Oh, sure. Russia-based service providers. Well, I think any penalties or any fines for doing business with Russia-based service providers really depends on the sector in which they're involved, and whether there are any sectoral sanctions that deal with the particular industry that they're in. And secondly, with regard to the nature of the advice or the deliverables that are involved. If the deliverables are involved entail anything that is controlled either under the export administration regulations, the ITAR or OFAC sanctions, then there would be sanctions based upon the nature of the content as well. So I think there has to be a dual analysis done as to who they are, what they're providing, and the industry and so forth.
And of course, payment could be an issue because of the financial sanctions.
Sure, absolutely.
Okay,
So I
great.
believe that there was another question that was being asked, which I think was addressed to me. I'm sorry that my connection was dropped. Do the same U.S. sanctions apply to foreign-owned companies with U.S. base and who are exporting from the U.S.? Richard, the answer basically is once a company, any company, is dealing with a U.S. origin technology or commodity, that U.S. origin technology or commodity is subject to U.S. export controls. So you have to look at what is it that's being exported, and whether that's a U.S. or foreign-owned company, if they're dealing with something that's controlled, whether it be technology or a commodity, then there are restrictions to abide by.
Excellent, thank you. We're getting near the end of our time, but we do have two questions in the Q&A panel that perhaps can be combined in an answer to save some time. The first is about armor for military projects made by Everts for U.S. military projects, and what are the restrictions there? And then also on the other side of things, are there any general exceptions made for healthcare or medical products to countries with sanctions? So if that can be addressed in combination, that would be great.
I can address the body question. I don't know if John can take the other, but in terms of body armor is controlled under both the ITAR and the Export Administration regulations. The determining factor as to whether the ITAR or the EAR applies is the level of protection that the armor provides. Armor is classified under National Institute of Justice standards, and NIJ standards 1 through 3 are controlled by the Export Administration regulations. If armor is at a level 4 or higher level of protection, it's subject to the ITAR controls.
Okay, very good. Kelly, you wanted to say something
David,
about the second question.
excuse me, I'll just quickly answer on the, what was it, medicine?
General exceptions for healthcare medical products.
There typically are exceptions written into the sanctions, and generally within a general license, there's going to be an allowance or an authorization for those items. You're usually in a general license going to have a carve out for health and safety types of products as well. So again, it depends on the sanctions program. It depends on the country and whether or not there's a general license that exists or not. But even with comprehensive sanctions on a country like Iran or North Korea, those types of exceptions do exist.
Okay, very good. Kelly, did you have something you wanted to say with regard to that?
Not with regard to that, but I have taken a number of questions over the past couple of months related to re-export and concerns by clients that their products, where they are controlled, are being appropriately handled by their distributors. And while, we teach and counsel about having a tight, export compliance program in-house, I wonder if, given our current environment, if John or Akana have any suggestions on sort of business process or the mechanics of working with your representatives overseas to fortify the compliance given this moving and evolving regulatory landscape that's changing a lot lately.
So I imagine John will have some comments as well. I'll try to be brief. There's no substitute for a competent and thorough export controls compliance program that ensures that you document every time you provided training for your foreign distributors that they should not re-export products that are not authorized to be re-exported. It's certainly true that U.S. companies, once products leave your dock, your loading dock, and they're shipped to someone far away, you can't always be certain what's going to happen to those products. But what you can be certain of is that you document the compliance requirements that you have put your distributors under, the training that they have received, and their understanding and acceptance of those standards, so that you can at least show you have done everything you possibly can to certify that you are doing the right thing, even if something that is unexpected happens by somebody outside your control.
Yeah, I'd like to say you don't want to get dragged into an investigation because of someone's wrongdoing. And again, it comes back to documentation, having your written compliance program, and then of course following it, as opposed to having a paper compliance program that nobody seems to know about. A lot of companies use BIS Form 711, the ultimate consignee and purchaser document that asks questions. I think the limitation there is that it's a BIS document. Number one, no one overseas wants to receive a US government document and fill it out completely, or at least there tends to be resistance to that. But more importantly, from my perspective, it does not address the sanctions compliance aspect. We didn't get into the 50% rule. I'm glad that Akana had it on one of his slides, but making sure that your distributors, your overseas partners are familiar with these rules and regulations is going to keep them out of trouble. Because if they're a valuable distributor to you, the last thing you want is for them to be subject to a possible denial order where they are no longer allowed to re-export US goods on your behalf. And you certainly don't want to see them be subjected to a significant penalty, which could threaten their existence. So pushing out the flowing down of export compliance is something that I always preach, and I think companies are better, better protected in that sense.
Great, thank you. I want to point out as we're nearing the end of our program here that Kelly has put a number of links in the chat that are very useful related to the discussion that we've had, resources for information. Also, this again, this is being recorded and will be available through the U.S. Commercial Service site. And I want to remind everyone to keep an eye out for subsequent lunch and learns as well. So I just wanted to get that out there. With that, it looks like Russ has a question. Russ, did you want to jump in? Okay, well, not sure how that's working, but we are at the end of our time. So I would like to thank everyone. Thank you, Akana. Thank you, John. Thank you, Kelly and Tom. This has been a good program. Hopefully people found it useful, and there is definitely a lot of other information that is available through the export councils around the country. And I think it would behoove you to engage with them directly. So thank you very much. And with that, we'll finish our program for today.
Thanks, everyone.
Thank you all.
Have a good rest of your day.
Thank you.
Good luck and goodbye.
Thank you all.
Bye now.